Hello and welcome everyone. I think we're live, so we're going to go ahead and get started on our presentation. Welcome and thank you for joining us for our webinar, SEC Compliance, Spotting Common Securities Law Issues in Transactional Matters, presented by Quarles. My name is Vanessa Meeks. I counsel investment advisors, investment companies, and their boards of directors and trustees on a wide variety of regulatory compliance and business matters at Quarles. Formerly, I served as senior counsel with the U.S. Securities and Exchange Commission for almost 11 years. At the SEC, I worked in the Advisors Act Rulemaking Office and also in Chief Counsel's Office in the Division of Investment Management. And more recently, I was in the Office of Investor Education and Advocacy, where I served as a subject matter expert on investment advisor and investment company matters affecting retail investors. Today, I'm joined by my colleague, Zach Pasker.
Hello, everyone. My name is Zach Pasker. I'm an attorney here at Quarles, and I advise fund sponsors on the full spectrum of private fund investment, fund formation matters, guiding them through structuring and fundraising. And I also counsel fund sponsors on regulatory and compliance matters. I also provide regulatory and compliance guidance to investment advisors and registered mutual funds in connection with their ongoing compliance and operations and investment activities, including with the Investment Advisors Act and the Investment Company Act.
We'll begin the presentation as soon as we cover just a few logistic items. So first, all comments in today's webinar are off the record and are not for publication. All attendees are in listen-only mode, but we welcome your questions via the Q&A box, which is located below the slides in the webinar dashboard. And if we don't have time to answer all questions today during the webinar, we can follow up over email. Quarles is happy to provide CLE credit in most U.S. jurisdictions for Quarles webinars. And as of April of 2024, the American Bar Association manages the CLE applications, attendance submission, and certificate of attendance for our external webinars. We have updated procedures for tracking attendance for CLE credit, and these include: you must be logged in, participating from your own device, and you need to actively watch the entire webinar. And so please watch for pop-up polls with an audio notification that will appear at several random times during the webinar. You must click on the pop-up polls to verify your attendance. And regulators require attendance to be verified, and this is the procedure that meets that requirement. Please take a moment to review the resources box below the video feed, where you'll find a copy of today's presentation, a survey link to share your feedback, and CLE application information. You can access closed captioning during the live webinar by clicking on the CC icon in the lower right-hand corner of the video player. And today's webinar is being recorded, so all registrants will receive the on-demand link within a few days. So with that, we will get started.
All right, so just to kind of go over our agenda quickly for today, we have a couple of topics we'd like to cover within this presentation. The first one is talking about investment companies and the Investment Company Act, including the issuing of securities connected to investment companies. We're going to talk a little bit about broker-dealer registration and what goes into that and some potential ways to avoid that. We'll talk a little bit about investment advisor registration. The exemptions I mentioned earlier, we'll talk in more detail about finders and the exemptions that apply to them within the context of M&A deals. We'll also talk about private fund managers, how they register with the SEC, and so on. We also have topics on family offices, and then just some general notes with respect to investment advisor planning, succession planning, and some of what that looks like from an M&A perspective, as well as just like a general day-to-day succession planning perspective. So to go ahead and kick things off, the first thing that we're going to discuss is investment companies. So, go ahead.
Sorry, can I jump in with one note on that previous slide?
Yeah.
I just wanted to provide just a brief overview of kind of our goals for today too. So securities law matters can come up in a variety of different contexts. So regardless of what area of law you focus your practice on, chances are you might come across a securities law issue at some point. So our goal today is really to help you identify some common issues that we see come up in a variety of transactional practices, and to help you issue spot those items when they arise. The securities laws are really vast, and you can't really become a subject matter expert in an hour webinar. But our goal is that having spotted an issue, you'll then know to dig a little deeper or to consider consulting with a subject matter expert if necessary. Because simply identifying a potential issue up front can really save your client or your company a lot of headache and potentially a lot of money down the line. And sorry, with that, I will turn it over to Zach to get started on the substance.
No worries. Thank you, Vanessa. So the first topic on our agenda is just to talk about investment companies generally and avoiding inadvertent registration. So really, what we want to point you towards is making sure that you can identify the situations that arise in everyday practice where an investment company could be accidentally or inadvertently formed, and then just give you some background generally on investment companies, how they're formed, what they are, and et cetera. So as a general matter, an investment company is defined as an issuer company that holds itself as being primarily engaged in the business of investing or reinvesting or trading in securities. And so what people typically think about initially is your traditional investment companies, mutual funds that buy and sell shares, in which you buy mutual fund shares. That's an orthodox investment company that's regulated under the Investment Company Act and the Securities Act. And that's what most people, I think, generally think about when they think about an investment company. But then there's also other circumstances in which an investment company can be formed, depending on the activity that you're engaged in, which, includes investing in securities, things of that nature, but not in the traditional sense that you would think of as, for example, a mutual fund. Because the SEC defines issuer pretty broadly to include any person or company that proposes to issue a security or has outstanding any security which it has issued. So again, that's a broad definition, doesn't apply just to mutual funds, and actually applies across a greater population of companies that might be engaged in investment activity. There's a couple of general rules that apply to investment companies. With the SEC, one of the key metrics they're going to look at is, whether, when you're operating an investment company, is a composition of, the assets of the company on a balance sheet. And in particular, they're going to look at, what kind of investment securities are on the balance sheet. And if that exceeds 40% of the value of the total assets on an unconsolidated basis, typically the SEC is going to find that company or that issuer is operating as an investment company. But with that general knowledge sort of set forth here, what we want you to do is, in these circumstances, stop and think about whether the offering of the securities could create an investment company accidentally, and if it does, that you're aware of and know of, available exemptions, so that way when these issues come up, there might be a couple of different routes that you can take to avoid registration under the Investment Company Act. And so just thinking about some common situations where a typical operating company might inadvertently become subject to the Investment Company Act, include, for example, an operating company that raises capital to finance its operations and then invest that in short-term, high-quality debt securities. an operating company that sells a substantial subsidiary, and before they redeploy the sale capital proceeds, they invest those funds in securities. So that's another way that an investment company might be inadvertently formed. Um, Another way it might be that, a company with strong cash flows or, irregular cash flows seeks to increase their earnings by investing in bonds or equity securities. Um, and then just one or two more examples could be for, an operating company that invests a substantial portion of their assets in securities, of subsidiaries, for example, that are less than majority owned, um, or an operating company that has relatively few good assets on its books. So those are just some ways that a typical operating company might inadvertently become an investment company based on its activities. And it could be totally one of those situations, like, for example, if you sell, in the early example, you sell a subsidiary, and before you redeploy those proceeds, you're going to invest them in some kind of other security just during the time before those proceeds are redeployed. So it's just something to keep in mind when a sale transaction like that might occur. You want to stay away from anything that could make the operating company an investment company. And so the other thing that comes up in this in this area is really just, what is a security? And of course, as you might expect, the definition of security has been defined very broadly. That includes, in the definition of security in the Securities Act, is a long list of all the devices that can be deemed a security in the eyes of the SEC. So, the things that probably come to mind immediately are, stock, notes, bonds, debentures, things like that. As well as puts, calls, straddles. Those are all securities. And then there's also sort of catch-all categories like evidences of investments, investment contracts, and the definition goes on and on. And so it is, as I mentioned, very broad. However, the Supreme Court has identified a couple of factors that it looks at, particularly the SEC, when determining whether a company that's issuing a security is actually issuing a security under the SEC's rules. So this case was known as the Howey test. And in this particular case, there were two Florida-based defendants that were offering real estate contracts for tracts of land with citrus groves. The defendants in this case, they offered the buyers an option of leasing purchased land, and then they would tend to the land, and then the defendants would also harvest, pool, and market the citrus and sell it. And because most buyers didn't have the agricultural expertise, they were happy to lease the land back to the defendants so they could take care of it and sell the produce. What the Supreme Court developed under the Howey test is that they were looking at whether or not this was an investment contract, which is included within the definition of security in the securities laws and regulations. And what they determined is that an investment contract is any situation in which there's an investment of money. So a buyer is putting in money towards something. There's an expectation of profits from that investment. So they're going to put money in and get money back out. It's in a common enterprise. So you're all investing in one, company or in one particular thing. And then any profit that comes from this is by the efforts of a promoter or a third party. So someone's going out and promoting the interest to be sold or whatever it might be. And then the Howey test, in this case, they use the term money, but that's since been, broadly interpreted to include things as, other assets other than money that could also qualify as an investment. So it really is broad, but at the end of the day, the Securities and Exchange Commission is really going to look at substance rather than form. So, it's going to go much beyond labels. So, if you call something, a thingamajig or whatever, that doesn't really matter. What the courts or what the SEC is going to do is look through the transaction to see what's going on. and make sure that those 4 items that I discussed earlier are either present or not present in determining whether or not something's a security. So again, very broad and something that is really a substance over form, going to look at the facts and circumstances of a particular case to determine whether something's a security. Next, I'm going to jump into some of the exemptions that you can look toward under the Investment Company Act. So 2 of the more common exemptions that we see often in our practice are to rely on Section 3C1 of the Investment Company Act, which is that you have less than 100 investors involved, and of those investors, no one was specifically formed for the purpose of investing. And so what you want to do is look at how many people are we bringing in making sure that that's less than 100, and that you fall under that exemption by having less than 100 people. And then the second most common one is under Section 3C7, which is that all investors have to be qualified purchasers. And qualified purchasers is a defined term under the securities regulations. And most of what qualifies someone as a qualified purchaser is their level of sophistication when making an investment, a certain excess amount of investment that they have. And what we often see is that to be safe, a lot of particularly our private fund sponsors that are raising private equity funds will attempt to rely on both, so they have a backstop if one or the other isn't available. So they'll look to make sure that they have less than 100 investors and that each of those investors is a qualified purchaser. Of course, depending on the circumstances of a fundraise, you might not always be in a position to have everyone be a qualified purchaser, but you can still look to that Section 3C1 exemption, 3C1 exemption to qualify under the exemptions from the Investment Company Act. And then one other item that we want to touch on from an exemption standpoint is that there are specific exemptions related to real estate funds. So, of course, under a real estate fund structure, everyone that's investing in the fund would still need to be an accredited investor under the Securities Act. But if the investments are limited to certain types of investments, for example, in mortgages, in liens on real estate, or interests in real estate, then they can rely on an exemption under the Investment Company Act under Section 3C5. So there are a couple of different routes that you can go to be exempt from registration or subject to the Investment Company Act. Again, often we see Section 3C1 relied upon, which is less than 100 investors, Section 3C7, which is all qualified purchasers, and then in the context of real estate, depending on what those investments are, you can rely on Section 3C5. So that's a summary of the Investment Company Act, what's a security, what's an investment company, and then the common exemptions that we see companies undertake with respect to the Investment Company Act. So with that, I will turn it back over to Vanessa.
All right. All right, thank you. So the next thing I want to talk about is broker-dealers and broker-dealer registration. So the Securities Exchange Act of 1934 defines the terms broker and dealer. The term broker means any person engaged in the business of effecting transactions in securities for the accounts of others. And the term dealer means any person engaged in the business of buying and selling securities for such person's own account through a broker or otherwise. Brokers and dealers are generally required to register with the SEC and with FINRA, and they're also subject to significant ongoing compliance obligations. And for any of you who don't work in this space, FINRA stands for the Financial Industry Regulatory Authority, And FINRA is an independent, non-governmental organization to which the SEC has delegated certain regulatory responsibilities. And this includes establishing and enforcing rules that govern the broker-dealer industry. So it's a pretty expansive regulatory space. So one of the places that we very often see that, there are kind of the traditional brokers, someone that you hire to transact securities for your investment account. It's pretty clearly a broker, not controversial, not going to be missed. The place that we often see issues arise is with finders who are hired to help connect investors with investment opportunities. And this can arise in raising capital for small business, with venture capital funds, with private equity funds. It often comes up when, someone running the fund or trying to raise the capital knows someone who has connections with investors who might want to make an investment, and they want to pay them for making introductions and helping to facilitate an investment. So it might be someone who's an expert in a particular industry and they have a lot of connections in that industry. It's not necessarily someone who considers themselves to be a broker. And the investments that people are looking to make in these cases are often securities, which then, brings you kind of back into potentially coming under that investment or that definition of being a broker. So these finders often end up performing activities that might bring them within the definition of a broker. And again, the SEC defines broker very broadly, and there's really very little that you can safely do without at least some risk of scrutiny. So some of the more common activities that we see these finders performing are due diligence, pre-screening of investors, recommending investments, and also receiving transaction-based compensation. So transaction-based compensation, this is really kind of a hallmark of being a broker in the SEC's mind. So that's compensation that is based on whether a deal goes through. So for example, a finder gets paid a percentage of the amount of the investment that's ultimately made, or even the finder just gets paid a fixed amount, but only if and when the investment is made. And really in our work, we often see finders agreements where neither party entering into the agreement has any idea that it violates the securities laws. They come to us wanting us to just take a look at this document, make sure the terms are fair, and we're like, hey, there's this pretty major potential issue here. These agreements can run afoul of both the federal securities laws and also of state law. And so why is this a big deal? Realistically, the SEC and FINRA are not going to catch all of these deals, but if they do, the consequences can be pretty serious. So anytime you have an arrangement where a party is being paid to help connect investors to a potential investment, it's really important to consider broker issues. And there are some exemptions, one of which Zach will cover later in this presentation, but even these exemptions are very limited and have to be approached with a lot of caution and a detailed analysis. So it's really important to spot when you have a potential broker registration issue. So some of the consequences of hiring an unregistered broker include cease and desist orders, civil and criminal penalties, and also rescission rights of investors. And then on the other side, if you're the one acting as an unregistered broker, you could be subject to SEC enforcement action. The issuer might be able to void the contract, refuse to pay you. You could also be subject to joint liability for rescission by investors. So this really isn't a situation that you want to find yourself in as either the one hiring the unregistered broker or the one acting as an unregistered broker. The next thing I want to cover is investment advisor registration. So the Investment Advisors Act of 1940 defines the term investment advisor. An investment advisor means any person who, for compensation, engages in the business of advising others, either directly or through publications or writings, as to the value of securities or as to the advisability of investing in, purchasing, or selling securities, or who, for compensation and as part of a regular business, issues or promulgates analysis or reports concerning securities. There are some exceptions for some of the more common ways that you might accidentally find yourself acting as an advisor. So I think overall, I at least have seen less instances of someone kind of inadvertently acting as an investment advisor, but there are still cases that aren't quite as obvious. So for example, there are exemptions for banks, lawyers, broker-dealers in certain circumstances that might kind of technically fall under that definition of investment advisor, but that's not really the heart of what they're doing as their business, and so they are exempt from that definition. Generally, investment advisors are required to register with either state securities regulators or the Securities and Exchange Commission, depending on the amount of assets they have under management. So 25 million and under in assets under management, you will always register with the states. Or you will always be, I guess I should say, you will be subject to state regulatory authority. Whether or not they make you register may be a different issue. Between 25 million and 100 million in assets under management, you will generally be subject to the state's jurisdiction, but with some exceptions. And then at 100 million in assets under management and up, you will fall under the Securities and Exchange Commission's jurisdiction. So the SEC interprets the definition of investment advisor very broadly. I feel like we have a bit of a theme here. Providing advice on picking an investment advisor, for example, would be investment advice. So that could be, someone's paying you to help them pick an investment advisor. And even though that person is not, that you're paying is not the one providing advice on securities directly, their role in helping you pick an investment advisor who will provide advice on securities will bring them within the definition of an investment advisor. Another way in which it's interpreted fairly broadly, advising to invest in something instead of securities is considered to be investment advice. So that would be something like telling someone, I think you should invest in this insurance product, which, may not be a security, instead of investing in mutual funds. In that case, you are providing advice to not invest in securities. So there are a number of kind of different roles that might land you within the definition of investment advisor. There are discretionary investment advisors, and those are kind of your traditional advisors who you turn your money over to. They make investments on your behalf. You don't sign off on each individual investment. In those cases, it's pretty clear that this person is acting as an investment advisor. But then you also get into stuff like financial planners. They might not be selecting individual securities for you, but they're often providing a bigger picture kind of map of recommendations for your portfolio. For example, they might be saying, weight a certain percentage of your portfolio in equities, pay down your mortgage with this portion of your portfolio. So that is another role that, not quite as obvious, but does also fall within that definition of investment advisor in many cases. And then another place that, another role that is within the definition of investment advisor is general partners and similar roles to private funds. So this is the entity with the legal authority to make decisions for the fund. And so it might seem somewhat obvious that they are providing advice on securities, but as I'll cover in a little more detail later, prior to Dodd-Frank, private fund managers generally didn't have to register as investment advisors. So sometimes I find that the registration and particularly some of the compliance that comes with that registration isn't quite as obvious or second nature to those managers in some cases. So with that, I will turn it back over to Zach to cover one of the common exemptions that in some cases can help when you find yourself in that situation of potentially being a broker.
Yeah, thanks, Vanessa. So as Vanessa alluded to earlier in the presentation, there is an exemption from broker-dealer registration that companies can look to in order to avoid registration. And it typically comes up, this particular exemption comes up in the context of like an M&A deal or a private equity deal in which the sponsor is trying to shop a new portfolio company to take on, and they're looking for someone to provide some type of support for that, such as an investment bank or whatnot. But while it is common, there are specific items that must be met in order for you to rely on this exemption. And so generally speaking, this was put out as part of a SEC no action letter back in 2013, and practitioners had relied upon the conditions in the no action letter in order to structure these types of finder relationships. But since 2013, that no action letter actually was rescinded and then codified. And there's a couple of differences, but the no action letter mostly remains intact. So what the law says now is essentially that M&A brokers are prohibited from relying on the M&A exemption if they engage in any of the following. First, in connection with the transfer of ownership of an eligible privately held company, which I'll explain in a bit, having custody or holding funds or securities for exchange in the transaction. Second, if they participate in public offerings of registered securities as part of the transaction. Third, dealing with shell companies, except for certain business combination related shell companies. They're not exempt if they provide financing for the transaction to the transfer of ownership of an eligible company. They assist in financing with unaffiliated third parties without complying with applicable laws and disclosing compensation in writing. They're not exempt if they represent both buyer and seller in the same transaction without clear written disclosure and consent. They facilitate transactions with groups of buyers formed by the broker to acquire the company. They're also not exempt if they engage in transactions involving the transfer of ownership with passive buyers. So the exemption is looking for an active buyer. And they also can't bind parties to a transfer of ownership of a privately held company. These factors are often worked into a finder's agreement at the outset of the transaction. So what you'll want to ensure is that when you're out seeking a finder, that you build out the finder's agreement such that they represent and warrant that they're not going to engage in any type of these activities in connection with the transaction. Now, in the perfect world, they're not going to do any of this. The agreement's going to say exactly what they're doing. But to get that as a rep and warranty in the finder's agreement, at least gives some recourse should they, stray away from what they're required to do in this typical M&A broker transaction area. So again, look to that finder's agreement as a space where you can outline these various requirements and have something in writing that establishes the relationship as an M&A broker exemption, including the other terms that you want to have within that finder's agreement as far as compensation and the like. I mentioned that there was a little bit of difference between what was the broker no action letter and now the codified version of that. And that focus is primarily centered on what the SEC or what the government has now defined as a eligible privately held company. So essentially, in order for you to go through with a transaction like this, the subject company has to be one of these eligible privately held companies. So first, that company cannot have any class of securities on a national securities exchange, or one that is registered or required to be registered with the SEC. Second, in the fiscal year immediately preceding the fiscal year in which the M&A broker services are first engaged for the transaction, the company has to satisfy one or both of the following conditions. The first condition is that the company's earnings before interest, taxes, depreciation, and amortization are less than $25 million, or the gross revenues of the company are less than $250 million. Finally, a finder is barred or disqualified from the exemption if either that particular broker or finder or its affiliates have been barred or suspended from association with a broker-dealer or have committed any so-called bad acts with the securities laws. So that's the a common exemption that we see people rely on or attempt to rely on. But it's important that while it's common, there are specific requirements that must be met in order for you to rely on that exemption. And then one other one that I want to cover really quickly, because it does come up from time to time. There's another no action letter that the SEC has out there that involved Paul Anka. And essentially this one is very limited, but I want to mention it anyway, which is he was going out and attempting to raise money for a hockey team and selling partnership units. And basically the conclusion that the SEC came to is that essentially when a finder does almost nothing more than provide names and phone numbers of potential investors to an issuer, that would not qualify them as a broker or dealer. But again, that's quite limited in scope. So the finder can't participate in any of the negotiations or the solicitations. They haven't previously engaged in any negotiations or solicitations, and they don't intend to participate in any securities distribution after the completion of the offering. So really what you're limited to under this no action letter is your Rolodex, names and numbers. So that's another path that you can go, but there's really no other involvement besides giving phone numbers and names. So that's another one that I just want to mention really briefly as well. All right, Vanessa, I'll turn it back over to you.
Okay, so I'm just going to discuss the requirements for private fund manager registration. So as I mentioned before, I think sometimes general partners and comparable managers of private funds don't realize that they need to register or at least report to the SEC. I think sometimes these kind of structures are being put together and the regulatory compliance that kind of comes after everything's been put together isn't necessarily the top of everyone's radar. So I think part of this is that prior to Dodd-Frank, there was an exemption for private advisors with fewer than 15 clients. And since the private fund is the client in the private fund space rather than the individual underlying investor, most private fund managers were able to rely on that exemption. And so more than a decade later, I think it's still just not the top of their radar that they might have obligations. So under 25 million, as I mentioned before, this applies for traditional investment advisors and also private fund managers. Under 25 million, you're under the state's jurisdiction. And many states have adopted exemptions for private fund managers. So sometimes these funds starting out are not big enough to need to report or to register initially. So this is an obligation that actually arises later. Exempt reporting advisors, also known as ERAs, are investment advisors that are not required to register as an advisor with the SEC or state regulators, but they still must pay fees and report public information via the IARD FINRA system. This is done through the Form ADV. So who can report as an exempt reporting advisor? It's fairly limited. Venture capital fund advisors, so this means you only advise venture capital funds, and then also private fund advisors with less than 150 million in assets under management. So ERAs report by completing certain sections of the Form ADV, not all of them like a fully registered investment advisor would do. And then ERAs are subject to some, but not all requirements of the Investment Advisors Act. So for example, the pay-to-play rule that limits services provided to government entities when certain political contributions have been made is one that does apply to exempt reporting advisors, even though they're not officially registered with the SEC. So generally, full registration is required above 150 million in assets under management, unless you solely manage venture capital funds. And just for what it's worth, that is interpreted fairly strictly. It's not something where you kind of say like, oh, I think these are all venture capital funds. That is something that does need to be taken seriously and analyzed closely. Registered advisors are subject to full regulation under the Advisors Act. So this comes with ongoing reporting and compliance obligations. And just a word of caution on this, don't try to avoid registration obligations by dividing up into multiple private funds. If it's really one advisor managing multiple funds, as determined by the SEC,